All right, good afternoon, everyone, and welcome to today's webinar. My name is Jorge Acosta Palmer, and I'm the director of the Statewide Training Initiative with Florida Legal Services. We're excited to have you join us today for Garnishment Defense 101, Understanding and Applying Exceptions for Low-Income Clients. Before I introduce our speaker, I do want to go through some quick housekeeping announcements. The training is being recorded, so if you register, you're going to receive a copy of this recording via email from Zoom within 24 hours. I'll also be posting the recording on YouTube. That usually airs with maybe by the end of the day, it should already be available so you can share it with others that were unable to register. So the training was approved by the Florida Bar for one General CLE Credit. So I'll announce the CLE code towards the end of the webinar. I'll also drop it into the chat. It will also be included in the email that goes out from Zoom, and I will also include it in the YouTube description as well. Closed captions are enabled for anybody who needs them. So if you're having any issues with accessibility or the captions, you can reach out to me directly. This webinar is being co-hosted by PILS, or the Public Interest Law section of the Florida Bar. So if you're not familiar with PILS, I'm going to drop the link for the PILS website into the chat. If you're a law student listening in, we have free membership for law students, and there's a lot of great opportunities to work with public interest law section attorneys. One of the most active work groups that we have in the section is the consumer tenant work group. So I can vouch for it because I'm usually attending those meetings. I know Michelle attends those meetings. So highly encourage you to look at the public interest law section website. So final piece of housekeeping announcements are questions and answers. If you have questions, try to use the Q&A feature. That way we can keep track of the questions and make sure that they're answered. If they're answered live, I can mark it as answered live. If what I'll do is if the question is related to the slide that we're on, I'll come off mute and I'll let Michelle know so we can try to address the question right there. If for whatever reason we don't address it immediately, I'll make sure to save some time towards the end so we can address any unanswered questions towards the end. So with that said, I'm going to go ahead and introduce our speaker. Our speaker is Michelle Trunkett. Michelle is the Advocacy Director with Florida Rural Legal Services, or FRILS, where she oversees advocacy efforts for attorneys and paralegals in the FRILS 13-county service area. Her work at FRILS began in '98 as a law school intern, and she later returned as a staff attorney and regional managing attorney in Fort Myers. She holds a bachelor's degree from Florida State University and a law degree from Stetson University College of Law. Michelle has concentrated her career on housing and consumer matters, serving as FRIL's housing and consumer work group leader and supporting advocates at her program in those areas. So without further ado, it is my pleasure to pass it over to you, Michelle. The floor is yours.
Thank you very much. Okay, so let's get started. As an overview, what we're going to be discussing today is the garnishment process in general, a review of different types of garnishments, a review of the most common exemptions that are applicable in garnishment cases, how to file those exemptions, and we're going to take a look at creditor objections to those claims. Before we dive into garnishment, I just wanted to do a to quickly show you all where garnishment fits within the broader set of collection tools under Florida law. These four writ-based remedies, attachment, replevin, execution, and garnishment, are the primary enforcement tools available to judgment creditors, and each serves a different purpose. A writ of attachment freezes the debtor's property before judgment to ensure that it'll still be available if the creditor ultimately wins. A writ of replevin allows the creditor to recover specific personal property that's being withheld. A writ of execution authorizes the sheriff to levy on and sell the debtor's non-exempt property to satisfy the judgment, and a writ of garnishment allows the creditor to collect from third parties who hold money or property belonging to the debtor. As you can see, these remedies differ based on when they can be used, what property can be seized, and who carries out the enforcement. Each method has its own process and procedural requirements. So personally, I've always found these to be a little confusing, so I found it easier to understand the writs by thinking about what each one is really doing. So if winning a judgment says you are owed money, then a writ of execution says sheriff, seize and sell property to pay the judgment. The levy says I'm the sheriff actually taking that property. A writ of attachment says sheriff, freeze the debtor's property now so it's still available at the end of this case. A writ of replevin says sheriff, seize and return my specific property. And a writ of garnishment says, hey, third party, hold that money. You might have to give it to the creditor. Okay, so now we're going to focus more on the garnishment of those options. Why are we focusing on garnishment? It is the tool most often used by against low-income clients, and it can have disastrous consequences. Even a short freeze on wages or bank funds can create a domino effect. Continued lack of access to money can cause clients to fall behind on rent and other essential bills, sometimes triggering evictions or other crises. So, understanding the process and the exemptions is critical to preventing that cascade of effect. Unfortunately, it's not uncommon for exempt funds to be routinely swept into these garnishments, and the very short time deadlines makes it crucial that they understand the steps that need to be taken to dissolve the writ of garnishment. So let's start with when can a creditor actually use a garnishment? So to use a garnishment, the creditor must have a valid and enforceable money judgment. That means a few things. First, the judgment has to be final and not stayed by an appeal or any other court order, such as a bankruptcy stay or otherwise. The second is that the judgment must be in the official record. For most of our cases, that simply means that it's going to be entered on the case docket. It doesn't necessarily have to be recorded as a certified copy. Finally, the judgments can't be expired. So most of us know that Florida judgments are enforceable for 20 years from the date they're entered. However, you might want to know that there's also a mechanism under Section 9511 that allows a creditor to file an action on the judgment and restart that 20-year clock. We just had one of those in our office a few months ago. As an aside, there are some extremely limited circumstances where a pre-judgment garnishment is available. I'm not going to be discussing those here, but you should know that it exists. Okay. Quick introduction to the parties. Because, as I said before, the garnishment involves a third party that is holding funds for the debtor, there are three parties to every garnishment case. There's going to be the creditor, so the party who won the judgment, the debtor, the party whose funds are being withheld or frozen, and then the garnishee. That's the third party that's holding the money. So it's typically going to be an employer or a bank. Okay, so this is a really quick overview of the garnishment process. I'm going to use a stoplight to explain this process. Um, but before I do that, let me walk you through how most people learn about their garnishment. They typically aren't learning about their garnishment from a creditor or from the court. Instead, it's likely been some time since that final judgment was entered, and maybe they'd forgotten about it or didn't know about it at all. And they usually learn about it in the most inopportune time when they're trying to use their debit card somewhere and it gets declined. Or they get their paycheck and they realize that it's short that 25%. That's because the garnishment process doesn't give notice to the debtor until after the garnishee is served. The garnishee is served first in order to immediately put a hold on those funds. And think about it, it makes sense. If debtors knew that their account was about to be garnished, there's a good chance that they wouldn't leave their money in that account, right? So instead, they typically find out after the hold is in effect, and when they come to you, they're usually freaking out about that. They think that their money is gone. They often also feel that that lack of knowledge before it happened is a personal offense to them. They feel like their bank or their employer acted wrongly for not giving them advance notice. And I say that because it's important for them to understand that this wasn't personal to them, that this is the garnishment process, and that the process is intentional about not giving them that advanced warning. So back to the stoplight. This stoplight analogy helps me explain it to them, though I will acknowledge, and some of you are probably already noticing, that it's not the best analogy because we're going backwards on the stoplight from red to green instead of green to red, but I hope it's helpful nonetheless. Okay, we're going to start with red. That's the freeze. This is where the court issues the writ and it's served on the garnishee. The moment it's served, the garnishee has to freeze the account or begin withholding wages. That's all the writ does at that point. It just creates a hold. At this point, no money is being turned over to the creditor. Everything is simply put on hold. And our clients need to understand that. Their money is still sitting there waiting for this process to play out. It's not gone. Next is yellow. That's the response phase. This is where the debtor can say, hey, now slow down. Let's see what we can do here. This is where the debtor can attempt to challenge the garnishment through the tools we're going to be discussing today. Each step in this process has its own deadline, but the case doesn't move forward until the debtor has had his or her opportunity to challenge that writ of garnishment, either through the motion to dissolve or an exemption. Finally, we reach green, and this is the decision stage. Not after the we can't get to this stage until after all the deadlines have passed and after the court has reviewed any exemptions or objections. Then it can enter a final judgment on garnishment, and that's the order that finally tells the garnishee what to do with the funds that they've been holding. They can either release it back to the debtor or they can forward those funds onto the creditor. So until the court gives that green light, the garnishee is simply holding the money. The garnishee can't release the funds to anyone until it receives that order from the court. Now I'm going to look at each of the types of garnishments separately. First, I'm going to discuss the bank garnishments or garnishment on any deposit account. These garnishments use a standard writ and function as a one-time freeze. When the writ is served on the financial institution, it has to review the account and freeze funds up to the amount of the judgment that are subject to garnishment. This can apply to checking accounts, savings accounts, credit unions accounts, prepaid debit accounts, any type of deposit account that the client that is or a financial institution is holding funds for a debtor. The scope of the freeze is limited, though, in two ways. First, it only reaches funds that are in the account at the time that the writ is served. So money deposited afterwards is not supposed to be captured in that writ unless the creditor goes back and gets a new writ. Secondly, the total frozen amount cannot be more than the judgment amount. There is a special rule for federal benefit deposits we're going to discuss a little bit in just a few minutes, but other than those public benefit protections, the financial institution doesn't get to make any decisions about what funds should be frozen. It just freezes the funds subject to the garnishment and waits for the court's word on how to proceed. Now, wage garnishment works a little differently. Garnishments are enforced through what's called a continuing writ. When the court issues a continuing writ, the employer is ordered to withhold a portion of each future paycheck on an ongoing basis. That withholding continues until one of three things happens. Either the judgment is fully paid, the debtor's employment ends, or the court enters an order modifying or dissolving the writ. A continuing writ applies only to earnings, meaning salary and wages. It doesn't reach bank accounts, commissions already paid out, or other assets being held. The key idea is that the writ captures future wages as they are being earned. There are automatic protections built in under federal law. The Consumer Credit Protection Act places strict limits on how much of a person's disposable earnings can be withheld. The employer can never withhold more than 25% of disposable earnings and cannot withhold any amount that would leave the worker with less than 30 times the federal minimum wage for that pay period. The good thing about that is the debtor doesn't need to file anything for these federal limits to apply. They operate automatically, and employers are responsible for calculating those amounts. Florida law provides additional protections that we're going to be discussing, but these are automatically applied at the time that the employer receives the writ of garnishment. So the important thing to notice about these two writs is how they behave differently. The standard writ freezes existing funds, and the continuing writ withholds future wages. Okay, so now we're going to look at how to challenge these garnishments. There are two tools that we can use to challenge a garnishment. First are the exemptions, which address the most important question, whether the money available is even reachable to the creditor or by the creditor. Exemptions protect the money the creditor is trying to take. And in this presentation, I have grouped these exemptions into two categories. The first are income protections, which depend on the source of the funds, things like head of family wages, child support, Social Security, public benefits, retirement income. The second group is personal property and account-based protections, which depend on the type of property or type of ownership of the property. These include exemptions like the statutory personal property exemption, the wildcard exemption, or protections for jointly owned property. A motion to dissolve, on the other hand, is used when the writ itself is defective. It can be filed by the debtor or by anyone else who has ownership interest in the funds. The motion typically argues that the writ was not properly issued and that the creditor failed to follow all required statutory steps. In practice, it is not uncommon for a debtor to file a motion to dissolve the writ to accompany a claim of exemption as well. Filing both together is common when the debtor wants to challenge the writ on multiple grounds, a procedural defect, and an exemption. Many attorneys file both to preserve all arguments. Note that there is also a rule that a writ will automatically dissolve if the creditor takes no action on the writ for 6 months unless the creditor properly files for an extension. Okay, I'm going to go over the timelines. Everything in this process begins with the writ once it's served on the garnishee. The moment it's served, like I said, a lien attaches to whatever the garnishee is holding for the debtor, even before the debtor knows exist. The garnishee has 20 days to file an answer identifying the funds it is holding. Their answer must state what funds or property of the debtors it is holding. And if the garnishee fails to answer, the court can actually enter a default and hold them liable for up to the judgment amount. After that, the creditor has to send a notice to defendant within 5 business days after issuance of the writ, or 3 business days after service, whichever is later. That notice is what triggers the debtor's rights that we're going to be talking about today. The debtor has 20 days to file either a claim of exemption or a motion to dissolve. Note one distinction in these timelines, though. For the claim of exemption, the debtor has 20 days from the date they actually receive the notice to defendant, where on the motion to dissolve, the debtor has 20 days from the date on the certificate of service of mailing of the notice to the defendant. So, and we're going to talk a little bit more about that, but I wanted to make sure that I made that distinction here very early in this training. If a claim of exemption is filed, the creditor then has 14 days to object if it was mailed, or 8 business days if it was hand delivered. If no objection is filed, the writ dissolves automatically. If there's an objection, the court must set an expedited hearing. A motion to dissolve, on the other hand, has no objection period. The court simply sets a hearing once it's been filed. Okay, so now we're going to take a closer look at the 20-day deadlines. As I mentioned, the statute seemingly provides 2 different ways to calculate the deadlines for the claim of exemption and the motion to dissolve. It's not clear to me that this difference of deadlines was intended. The deadline for the motion to dissolve is contained in section 77.07 and 77.055. 77.077 says the defendant and any other person having an ownership interest in the property, as disclosed by the garnishee's answer, shall file and serve a motion to dissolve the garnishment within 20 days after the date indicated on the certificate of service on defendant and such other person that the plaintiff's notice required. Then in 77.05, it states that the plaintiff shall serve by mail certain documents, one being a notice advising the recipient that he or she must move to dissolve the writ of garnishment within 20 days after the date indicated on the certificate of service. So that seems pretty clear in the statute. However, in my experience, the only notice that's sent out to debtors is the notice to defendant, which is the notice required within 77041. And I've copied portions of that notice here. And if you go to the statute, this whole notice is written right into 77.041. And if you notice it, this language in this notice doesn't actually mention a right to dissolution, nor does that deadline track with the deadline of the 2 statute sections that I read in the former slide. The notice to defendant actually only discusses a right to file a claim of exemption and puts the debtor on notice that they have 20 days from the date that they receive the notice to file their claim of exemption. So, yeah, for me, that's a discrepancy. I mean, not necessarily because they are 2 different avenues, different ways to challenge, but why I'm concerned about it is that there is no wiggle room when dealing with these deadlines. One of the most important things to understand about these time deadlines is that the courts strictly construe them. The garnishment is purely statutory remedy, so every step must comply exactly with what the statute requires. So there's no leniency built into this process. If a debtor misses a deadline by even a day, a court routinely holds that the right to challenge the garnishment is waived. The timelines for filing a claim of exemption, the creditor's timelines to object, and the deadlines for a motion to dissolve are all enforced exactly as written. In fact, 77.07 specifically says that failure of the defendant or other interest party to timely fail and serve the motion to dissolve within such time limitation shall result in the striking of the motion as unauthorized nullity by the court, and the proceedings shall be in default posture as to the parties involved. And there's a case, and if you all haven't read it yet, I recommend that you do so that you understand how the courts look at these deadlines that emphasize this is Zivitz versus Zivitz. In that case, the court held that when a debtor failed to timely file the required response, the court had no discretion to overlook the defect. The late filing was a nullity because the statute requires strict compliance. The court also rejected, and we're going to talk about this in a moment, the idea that the phrase in the notice of defendant says may lose important rights, which could be construed as softening that deadline. The court felt that the isolated use of that phrase didn't negate the necessity of the timely compliance. And really, they felt that it went more to whether or not there was a guarantee to the exemption if they met that time deadline. So you can see why it's important that these deadlines are critical to understand in order to challenge the garnishments. I do want to state that Florida courts have also made it very clear that hardship is not going to be a factor in analyzing the deadlines. And if one's missed by no matter how much of a hardship is presented, the courts don't really have the ability to ignore the time deadlines that are set in the statutes. So there's just really no discretion allowed according to the court's interpretations of these statutes. And so this strict constriction rule applies to both sides. Just as a debtor can't file late motions or claims, the creditor must meet their deadlines for serving their notice to defendant and for their objections. Any failure on either side can invalidate that writ. So, what and I think I'm not sure that I explained this. My concern is that when the creditor is supposed to send if the creditor is required to send the notice to the defendant that they have the right to file a motion to dissolve the writ, and they have 20 days to do that from the date of the certificate of service of that notice, the the notice that is actually sent, in my experience, and if anyone else has a different experience, I would be happy to know that, doesn't ever actually mention their right to challenge to dissolve the writ and that different deadline. The only deadline that most people are receiving is what's contained in this notice to defendant in 77.041, which tells them they have a right to file that exemption, and they have 20 days from the date they receive it to do so. So, I say that because I don't want to leave you all feeling helpless if a client comes to you in the door with the 20 days has already lapsed. In my opinion, not all is lost at that point. Here's a few tips. So first, find out if your client ever actually received the notice to defendant. Most of these garnishment cases stem from old credit card cases. It's not unusual for creditors to seek writs of garnishments 5, 10, 15 years after the entry of the final judgment. And we all know that many of these judgments were obtained through defaults. Those cases could have been filed more than 4 years after the debtor stopped paying those credit cards. So think about how many years may have gone by since all this has happened and how many times the debtor may have moved in that time. According to a study done by the Urban Institute, 57% of residents in disadvantaged communities move move at least once within a 3-year period. So think about it. In all those years since that default on the debt and then the final judgment and the time since then, how many times might that debtor have moved since the creditor or its predecessor had a good address for that debtor? My experience is that the court dockets show that the notice to defendant is very often sent to an address that my client hasn't lived at for many, many years. That means they never actually received the notice to defendant in most cases. And so, in my opinion, that means the clock for the deadline of the claim of exemption hasn't even been triggered yet. They still have that 20 days because they haven't received that notice. If you're using the language that's in the notice to defendant. Or you can consider whether the plaintiff can even establish when the notice to defendant was received. There was at least one case, it was a Bay County case, where the court found that since the plaintiff could not establish the date of receipt by the defendant, the court could not conclude that the claim of exemption was filed untimely. And I've listed that case citation here. It's a Florida Law Weekly supplement case. Second, if your client did truly miss the deadline to file a claim of exemption, see if the plaintiff ever gave notice that they may file that motion to dissolve that was required in those two sections I started with. If not, you may be able to attack the writ by the plaintiff's failure to properly execute that writ. The goal here would be to force a creditor to start the garnishment process again. Remember, the creditor is not precluded from seeking a writ of garnishment repeatedly throughout the life of the judgment. So if you can challenge the validity of the writ itself, get it dissolved, they can always refile that writ of garnishment, but it will allow you a new window to file that claim of exemption. Finally, ask your clients if there have been any changes in circumstances. At least one court has found that it could reverse a previously denied claim of exemption based upon the change of circumstances. Okay, so now we're moving into the discussion about exemptions. Up to this point, we've talked about how garnishments work, the procedures, the timelines, the notices, and the ways creditors move out of a client's reach. Now we're going to shift to the part of the analysis that truly drives whether our clients keep their money or lose it. That's the exemptions. For most low-income clients, exemptions are not just technical defenses. They are the legal protections that keep families housed, fed, and stable. And in practice, exemptions are where most garnishment cases are actually won or lost. So we're going to move into this next section. Keep in mind that everything we've discussed so far, the deadlines, the notices, the motions, they exist to make sure these exemptions are properly asserted and protected. This is the heart of the garnishment defense, and this is where advocacy can make the biggest difference. Okay, so I feel like I say before a lot, but before we get into the mechanics of specific exemptions, I wanted to pause and talk about why these protections exist in the first place. Florida's exemption laws were not created to give debtors an unfair advantage, and they're not designed to help people avoid legitimate obligations. Their purpose is far more fundamental, and I've listed some words here that courts have used to express the purpose of exemption, starting with the Florida Supreme Court in the Patent Package Company versus Hauser case that I've listed here. The court in that case says that exemption laws exist to prevent an unfortunate citizen from being deprived of the basic necessities of life. They are meant to preserve for the debtor and the debtor's family things that are reasonably necessary to maintain a livelihood. And when someone earns that livelihood through their own labor and services, the law protects those earnings so that the debtor and the debtor's family are not left destitute or forced to rely on charity. That's the foundation of the exemption system. It's there to protect people from becoming public burdens and ensuring that they have the means to sustain themselves while still contributing economically. And because of that purpose, the court in Patent Package emphasized that the exemption statute should be liberally construed in favor of the debtor. And this isn't an isolated principle. Florida district courts have repeatedly reaffirmed it over the decades. There's numerous decisions from DCAs recognizing that exemption statutes must be read broadly to fulfill their protection function and to ensure the debtor and the debtor's family retain the resources necessary to maintain basic living standards. Modern courts continue to apply this approach and I don't know if I could say this correctly, Ulisano versus Ulisano, which is a fourth DCA case. That court explained that determining whether an exemption applies requires looking at the totality of the circumstances. Courts do not apply these protections mechanically. They evaluate the debtor's entire situation so that the exemption statutes can operate as intended. So, as we walk through these exemptions today, whether income or protections, personal property protections, or bank account protections, keep this purpose in mind. And I'm going to go through some analyses that courts have put forward just to help everyone know how to analyze different facts and see how courts might interpret those in light of this purpose. And so, okay. So we're going to start with head of family exemption. This is one of the strongest protections, and it stops most wage garnishments completely. It does have three parts. All three need to be understood in order to apply it correctly. First, the exemption applies only to wages. Second, we look at the income rule. If the person takes home $750 a week or less, or if they make more than that, but they haven't signed a valid written waiver, then they're going to meet that second prong of this rule or of this analysis. And third, we're going to confirm that the debtor provides more than half the care for a dependent. And we're going to look at each of these criteria a little bit more in depth to understand how those are applied. When you put these three parts together, wages, income limits, no waiver, and providing more than one half the support, that's together, all three of those make the head of family wage exemption. So let's look at these individually. What counts as wages? When we apply the head of family exemption, the first question we ask is whether the income is actually wages, meaning is it money earned through the client's labor or the debtor's labor. This includes hourly pay, salary, commissions, bonuses, tips, and gig work payments. It really doesn't matter if the client was paid through different forms. They could be paid direct deposit, cash, through an app. As long as it was money earned through work, it is going to be treated as wages, or at least you have a good argument that it should be treated as wages. It also doesn't matter if how the employer labels the debtor or the client. They can label them as an independent contractor or not. However it is, the court's going to be looking at what they're doing to get that money, and if it can be classified as works or labor, then I think you can make that argument. On the other hand, passive income like rental income, investment income, business profits, people who are self-employed may have a little bit more difficulty establishing whether income is through labor or whether it's a business profit that didn't come from personal labor. Those are not going to be exempt under section 2222.11. Okay, so as I mentioned earlier, even if a debtor earns more than $750 per week, their wages are still protected unless they signed a valid written waiver. Florida law is very strict about what qualifies as a valid waiver. First, the waiver must be written in the same language as the contract or agreement that it relates to. Second, the waiver must be in a separate document that is attached to the contract or agreements. So it can't be buried inside a paragraph or fine print or included as a clause within a credit application or within any other financial documentation. It has to be a standalone document. Third, that separate document must contain the exact statutory written warning language in at least 14-point type telling the debtor that if they provide more than half the support for a child or other dependent, their income is exempt from garnishment, and they can waive that protection only by signing this waiver. Finally, the waiver must be signed by the debtor. Well, I'm sorry, that's not finally. Actually, it also requires that the creditor has to sign off that they explained the contents of that notice to the debtor. In practice, very few creditors can actually satisfy all these requirements. Most waiver language is embedded inside long loan agreements or is missing in the mandatory statutory warning. So, this is an important thing to look at if your client makes over $750 and is facing a garnishment. Unless that creditor can produce a waiver that meets every one of these elements, the debtor's head of family wage protection probably is going to remain intact. Sorry. Okay, now we're going to talk about proving support. To qualify for the head of family exemption, the debtor has to be providing more than half of the support for a child, spouse, or other dependent. Support can include rent, utilities, groceries, transportation costs, childcare, medical, any of the basic expenses of daily life. The dependent doesn't have to live in the same household or even necessarily be related to the debtor to be considered a dependent. To prove support, we usually rely on proof of payments such as bank statements, receipts, pay stubs, bills. But really, this is where we're going to find that testimony is going to be very important. The key is showing that overall, the debtor is covering more than 50% of what the dependent needs. Many of our clients meet this requirement even if they don't realize it, especially single parents or primary caregivers. However, this prong can allow for some really creative arguments on both the creditor side and the debtor side. So don't take it for granted that if your client is providing more than half of the support for a dependent, that's going to be accepted without some sort of documentation. Make sure that you understand all funds and the source of those funds that contribute to the care of that dependent. Does the household receive child support, financial assistance from churches or charities, other familial support? Those are things that the creditors might be looking at. Creditor attorneys are going to look at these sources of support, so you need to be aware of how these amounts will play into that more than 50% calculation.
Michelle,
Um,
I was going to ask you,
yes,
could you go back 2 slides to the waiver slide because there was a question
sure,
related to the waiver?
sure.
And so the question is, why would anybody ever sign such a waiver? Doesn't make sense for somebody to sign the waiver. So,
Yeah, I don't know. I don't have an answer for that, but it is a little surprising that anyone would do that. And quite frankly, if I did have a client that signed it, I would be asking them why too, because maybe that would lead to another way to discount that waiver. Maybe it wasn't explained. Maybe it was explained, um, you know, incorrectly. Maybe it was in a different language. We really don't know because it does beg the question why anyone would sign that. Or maybe they were felt like they were forced to do so. Is that it?
yes, that was it. Sorry, I couldn't
Okay,
unmute
very
myself.
good. Okay, thanks. Okay, so I am going to go over a few cases. I think that because there's this support of a dependent brings up a lot of different circumstances for a lot of different people. Um, it requires kind of looking at how courts have looked at this. And I really show this here because I want to encourage you that when you are talking to clients and they're telling you who they feel they're responsible for, don't automatically discount it because it doesn't fit the traditional model of who we consider to be a dependence. So let's start with this Killian case, in which the court says to us, it makes little difference whether the wage earner is residing in the same house with a wife and or family, or whether he is living elsewhere in a divorce status. Rather, it is the obligation to support that family and their dependency on him that should control, not the aggregation of all the parties under one roof in a state of connubial bliss. I don't know if I said that correctly. The court in Mazzella versus Boynes, again, I think I might not be saying any of these correctly, used the family in fact test. And that court found that there should be a showing of either the existence of a legal duty to support arising out of the family relationship at law, or in the alternative, a continuing communal living by at least two individuals under such circumstances that one is recognized as in charge. Then there's this Broward County case in that where the court says exemption statutes should be liberally construed in favor of the debtor. This court finds that the otherwise undefined term of other dependent in section 222.11 should be construed in favor of the debtor and applied to the debtor's elderly and unemployed parents. A few more. In this Grove financial case out of Polk County, the question now turns to whether debtor's girlfriend's child is a dependent of the defendant debtor. Since no definition exists within the statute, we again must first consider the plain meaning of the term dependent. And it goes on to read the statute, the definition. Dependent is used as a noun. The term dependent as a noun is defined as one who relies on another for support. So using that's pretty broad. This court has considered in this analysis of a dependent determination the controlling facts of this case, steps which minimally include a determination that the dependent is of the debtor, a determination that a good faith dependency relationship exists with the debtor, and a determination that the debtor is providing more than one half of the support needed by that dependent during the dependency relationship. So you can see that the courts here are not looking at traditional relationships, and that you can use some of these definitions to include a dependent that maybe you might not have been thinking about when you first started, working on these cases. A few more. Defendant provides more than one half of the support for his uncle and therefore qualifies an exemption. The next one is really interesting, and I really like how the court looked at this one. This is out of Orange County, FIA Card Services versus Phillips. In this case, there was a debtor that was married and had one child with his wife, but he also had two older children from a prior relationship that he was caring for. And in this situation, the wife earns more money than the husband. So as to the child of the marriage, the husband couldn't qualify as the head of his family because he wasn't providing more than half the care for that child. However, the court found that he could qualify as head of family for the older two children because their mother were not contributing to their care, and the debtor provides the majority of that support. So the court applied the Supreme Court's mandate that exemption statutes be liberally construed in favor of the debtor. The court explained that if it's this court's opinion that debtor shouldn't be penalized by not being able to take advantage of his exemption rights simply because he is married. His wife earns more, but that shouldn't prevent him. So I thought that was a nice way to broaden that scope for that debtor. And then I think this is a repeat about the uncle, and then there's one where the defendant was providing more than half the care for her adult son and his minor child and was able to claim those. So just keep those in mind when you're talking to your clients. So many of our clients are supporting people that they are living with, aren't living with, related to them, not related to them. And I think that these cases kind of give you an idea of how you might be able to use those relationships to determine if they can meet that third prong of that analysis for head of family. Okay, so now once we've declared that wages are protected, they don't lose that protection once they're deposited into a bank account. Under section 222.11, exempt wages remain protected for 6 months after the deposit as long as the debtor can trace and properly identify the funds as earnings. So this is called the tracing rule. To trace the wages, we usually rely on bank statements, direct deposit records, pay stubs, or employer confirmations. Even cash wages or gig economy payments can be traced if there's a consistent pattern of deposits. And you might see that in some of these other types of accounts where they get direct money from individuals as part of their earnings. Florida law also recognizes that wages may be mixed with other funds in the same account. That statute specifically says that commingling does not necessarily defeat the exemption by itself, but courts do differ on how they analyze those withdrawals from mixed accounts. Some courts are going to use the first in, first out approach, while other courts are going to be applying those withdrawals first to non-exempt funds before the other funds. So obviously and if we're representing debtors, are going to try to use the non-exempt funds first approach so that we can maximize how many of the funds in that account are going to be exempt. You want to keep this rule in mind also when we talk about bank garnishments, because when we're analyzing what's in those accounts, we're going to want it. So it's not just going to protect the wages here at the wage garnishment, but in the bank account garnishments as well. Okay, I'm not going to spend too much time on the next few slides because they are generally well accepted income exemptions. I just wanted to make sure to list them here so that everyone's familiar with them, but we don't need to spend a great deal of time on them. So first is child support. Since child support belongs to the child, not the debtor, those funds cannot be garnished. Once traced, courts routinely will treat these funds as fully protected. Public assistance funds are not the debtor's property, so they cannot be garnished. So you're looking at SNAP, TANF, foster care payments, adoption subsidies. These are all going to be treated as funds belonging to the child or the household. Likewise, unemployment benefits and workers' compensation benefits, including settlements, are not going to be garnishable. ERISA payment retirement plans such as 401ks, 403bs, federal pensions, military retirement, railroad retirement, and Florida public pensions are also going to be exempt from garnishment. And then finally, federal law makes federal benefits such as Social Security, SSDI, VA benefits, federal retirement, and railroad retirement fully exempt. The protection continues after deposit, especially with direct deposit, and commingling does not necessarily destroy that exemption as long as you can identify the source. Now, if they are one of these protected federal benefits, banks do have a duty to protect them. When they receive a garnishment, the banks are required, unless there's a special notice of right to garnish federal benefits, which is rare, the banks are required to perform a 2-month look back for direct deposited fund federal benefits. They need to protect that amount so the customer has full access, and they are not to freeze or turn over those protected funds or charge garnishment fees. However, there is a safe harbor provision in this rule that protects the banks if they act in good faith. So typically what's going to happen is if once they realize an error, they're going to correct it, immediately make those monies available, and they're probably going to be found to have been acting in good faith. So there might not be much to do about these types of cases. Okay. And then finally, these less common income sources are all exempt. I'm not going to read them all, but the slide will be available, and there are other exemptions. And I will say that one tip, if you have something that you're not sure whether it should be exempt or not, and you can't find it, if anyone practices bankruptcy and has access to bankruptcy software, I personally go to that software, and they have a list of all the exemptions there, but some that I've never heard of, and you could do a double check there, and obviously you're going to check them to make sure it's correct, but that gives you a much broader list of exemptions that are available. So if you have access to that, that's another resource. Okay. Now that we've covered the income-based exemptions, I want to shift us to the second major category of protections, which are the personal property exemptions. We're typically using these exemptions in bank or deposit account garnishments. First is the basic personal property exemption under Article 10, Section 4 of the Florida Constitution. Debtors in Florida are entitled to protect up to $1,000 of personal property. This can include things like bank account funds, cash, furniture, clothing, electronics, whatever items they want to designate as protected, they can do that, and everyone's entitled to this protection. It does have to be claimed, though, in the garnishment case with a personal property inventory, so the debtor can identify which items or funds they want to apply to that $1,000 exemption. Then there's the wild card exemption under section 222.25. Under this section, if the debtor does not claim the constitutional homestead exemption, they are entitled to an additional $4,000 in personal property exemptions. When combined with the standard $1,000 exemption, that means a debtor can protect up to $5,000 in personal property. Again, the key is that they need to not be claiming the homestead exemption to be able to be entitled to this. And you need to allege that if you're going to claim that wild card exemption in the claim of exemption forms. And just like the personal property exemption, it requires a property inventory under section 222.12, and they need to designate what they're claiming as exempt. And we'll go over that in just a moment. Moving on to ownership-based offenses, these are protections that apply when the money in the account doesn't legally belong to the debtor. Under 77.01, a garnishment can only reach the debtor's property. So if the debtor doesn't actually own the funds in the accounts, then the writ simply can't attach. So these are going to include accounts owned by a spouse. You're looking at tenancy by the entireties, or maybe just a joint account. You might be looking at a representative payee account for Social Security or other benefits. And sometimes people are, share accounts for other reasons as well. I'll start with tenancy by the entireties. This is going to be the strongest ownership-based offense. It's for married couples that hold tenancy by the entirety, and the laws to treat the two spouses together as one single unit so that the creditor of just one spouse can't attack that account that's not owned by the one creditor. I'm sorry, the one debtor. So Florida requires 6 unities for a tenancy by the entirety account, and I've listed them here, but I'm not going to go into them because the practical rule is much simpler. Under the Florida Supreme Court's Beal Bank decision, when a married couple has a joint account, the law presumes it is held as tenancy by the entireties unless the account documents say otherwise. And that means that the burden then shifts to the creditor to show that the account is not a tenancy by the entireties account. So this is kind of the first thing you want to look at when you have a married couple, an account with a married couple. Not to say that the creditor is not going to try to attack it. They might, but there's some pretty good strong foundation for this exemption or defense. Joint accounts are not held as tenancy by the entireties can still provide strong protections. A common example that I've worked with a lot seems to be adult children who share accounts with their parents because their parent opened or created that account while they were still a minor. But then as they go into adulthood, they use those accounts individually and solely, and all the deposits can be shown to be their wages or their income. And so if you have that situation or any other type of debtor or joint account, if you can show that the money that's been deposited into that account is solely from the other party, you should be able to defeat that garnishment on that account. Also note that if the bank identifies a second party to that account, that creditor is required to send notice to that second party on the account as well, so that they have the opportunity to contest it. Okay, so now that we can recognize the exemptions that are available, we're going to walk through the procedure for filing the claim of exemption. It begins with the debtor completing and filing the claim of exemption and request for hearing form. This is that statutory form. This is a statutory form and should have been provided to the debtor with the notice to defendant. The debtor is going to have that 20 days that we talked about from the date that they received that notice to debtor. It's got to be signed under oath. And for most people, that will require a notarization, although I think you can do an unsworn declaration. The key point is that the form must reflect a sworn statement. If the debtor is claiming a personal property exemption, they also must file that verified inventory of their personal property that we discussed. A few tips. I've we don't have to wait till the 20th day to file these. And they're pretty simple forms. File them early because everything is timing is triggered by the filing of the claim of exemption. So when we then flip it over to the creditor having a right to object, the sooner we get that claim of exemption filed, then the sooner that time frame is triggered. And this is all really important because, or at least for the client it is, because every day before that hearing or before that release of those funds, that money is sitting, it's unavailable to them, or they're getting less in their paychecks, and those other bills that they have to pay are mounting, and we want this process to go as fast as we can for them so that they receive the least amount of damage from this garnishment. So I just recommend filing as early as I can. These are cases that are meant to be expedited on the court's docket, but I also feel like these are cases that need to be expedited for us. I try not to have much of a delay with meeting with clients or getting this done because, like I said, timing is everything in these cases. Make sure before you file it that you review all the exemption boxes. Debtors often overlook some when there's multiple exemptions, and then some exemptions are not even listed on the form, so you may need to add some of those yourself. And then I recommend attaching or sending supporting documents to the creditor and filing a notice of that in the court so that everyone is aware that the creditor is has the documentation to be able to make that assessment themselves as to the validity of that claim of exemption. Okay. This is the statutory notice. We talked about this earlier. I'm not going to go back over this, but read that notice if you haven't done so in 77041 because a lot of rights are in that notice that aren't anywhere else in the statute. Okay, so now we're going to talk about this property per the property inventory requirements. When a debtor claims any personal property, they're required to file this verified personal property inventory. It comes up in sections 222.12 and 222.061, and it applies regardless of whether the debtor is claiming which personal property exemption the debtor is claiming. It's not required in wage garnishments, though. So it has to be verified, and it needs to list all the personal property owned by the debtor. It needs to list the estimated fair market value of each item, the total value of the property, and the identification of which items the debtor is claiming as exempt. And the debtor gets to choose which items they're going to claim as exempt, not the creditor, not the court. The court's role is simply to confirm whether the value of those items fits with the statutory limits. So here is a sample of a property inventory. Don't make this more difficult than you need to. I usually just give the fair market value, which is really hard for clients to do. I try to use the retail resale value, and so I will ask them if they had to buy their kitchen table in its current used condition, how much would they buy that kitchen table for now at Goodwill? And that usually gives them a pretty fair number, reasonable number that we can use. Also, don't forget to reduce any values for liens. So, example, if you list a vehicle and that vehicle has a car loan on it, you should list the value of equity that your client has in it. But I do make a notation that how I came to that number so the court's familiar with that. Most of our clients' personal property is going to total well under the exemption limit, and so the goal is to really just show everything so that the court is aware that all the clients' assets are going to be protected. So you might need to list other exemptions that we haven't discussed here. For example, the motor vehicle exemption, if the client owns a vehicle. After this, after we have filed a claim of exemption, the next step is for the creditor to dispute it if they so choose to do that. If the creditor wants to challenge the claim, they have to file a timely written objection, and it has to meet several requirements in order to be valid. First, the creditor has to identify the specific exemption being contested. Then they have to state the reasons for contesting the exemption, and then the creditor has to file that objection within the statutory deadlines. There are several grounds that they might use. They might claim, like I said before, that the TBE hasn't been met, or insufficient evidence. But if I'm being honest, most of the creditor objections are going to be pretty general. They're typically going to just do a blanket denial and not give much explanation. So I'm going to read from sound. I do just want, I know we're running out of time, but I think it's important to understand why some of these objections are not meeting court requirements or the statutory requirements. In this first case here, the court found that the plaintiff must file an affidavit that contravenes the defendant's claim of exemption. Merely filing a document under oath does not make that document an affidavit. The word affidavit actually has a distinct, clear legal meaning. Central to an affidavit is that an assertion of facts made under oath and that the affiant have personal knowledge of what is being asserted. So whether the plaintiff filed their objection, it's not based on personal knowledge, and the court found that the objection was not sufficient to be able to contest that claim of exemption. This is kind of language in quite a few cases. The plaintiff's objection is insufficient as a matter of law because it's not based on personal knowledge. But then it goes on to say it appears that the plaintiff is attempting to use garnishment as a substitute for discovery, and basically says you can do that through other means, not through the objection of the garnishment. This one was thrown out because it wasn't even properly sworn to. The court found that it failed to include the venue of the notarization, the exact date of the notarization, and the specific type of identification. So this court went straight to the whether or not the notary requirements were met, and failed to allow that objection to stand. Okay, I just have two more slides, so I promise I'll go very quickly. At this stage in the process, the hearing becomes necessary only in two situations: if the creditor files a timely and proper objection or to the claim of exemption, or if they file that motion to dissolve the writ. The Florida law requires these hearings to be set expeditiously, which is the legislature's way of saying that the court should not delay. The scope of the hearing is going to depend on what you guys raise, but at the end of that hearing, the court is going to decide either to dissolve the writ entirely, to deny the claim of exemption or the motion to dissolve, or maybe a combination of both. The court might designate some of the funds are exempt and might designate that some of the funds need to be released to the creditor. Really quickly, just some alternative strategies if you're working with people who are being garnished. You can try to negotiate with the creditor. There are a lot of the creditors will offer to do this, and they might be willing to, if you can't challenge the garnishment, maybe what you can do is get less than 25% of the amount garnished. I've heard creditors offer 15%, and that 10% can make a significant difference for the clients. You can also explore payment plans, hardship agreements, or other reduced payoff agreements. Another one is to consider whether bankruptcy is appropriate. Obviously, you need to look at the totality of the circumstances, but the nice thing about bankruptcy is it will stop that garnishment immediately if it's filed, where I've had some garnishment cases go on for months and months. I think wrongly so, but that was the reality, and my client had to suffer those consequences for months, even though we were ultimately successful in the claim of exemption. And then there's at least one case that mentioned a change of circumstances and overturned an earlier decision on denying a claim of exemption based on the fact that there was a change of circumstances. So take a look at that as an option. And finally, I'm not saying this is the best option, but the writ of garnishment is only applicable to the garnishee listed. If this is an employment or a wage garnishment, and that client no longer works for that employer, that garnishment no longer continues. I'm not suggesting that quitting a job is the best response, but I have had clients that have found that to be more reasonable of an option for them if they didn't qualify any other exemptions, assuming that they were able to get other positions. And then finally, I just want to say, again, timing is everything, but I just want to point out that creditors can come back and do these exemptions or these garnishments over and over again. As a practitioner, you should either withdraw at the end of your claim of exemption or at the end of that dissolution of that garnishment, or you can do a notice of limited appearance and a notification of conclusion of services. Because what you really don't want to happen is to have that client's case keep coming back to you and those notices defendants come back to you, and then you have to go and find out where that client is and restart that whole process. So that's just a little tip at the end of the case. Make sure that you properly withdraw or end your representation in that case. And that's it. I'm sorry I went over by 4 minutes.
Totally okay. I do have the CLE code that I want to read out loud. I dropped it into the chat. The CLE code is 2513678N. This will go out via email, so you're not gonna miss out on it. There were a few questions, Michelle. There's one that's kind of a should be an easy one, so I'm gonna start with that one. And the question came in through the Q&A, and the question is alimony exempt from garnishment?
Is alimony exempt for garnishment? I don't want to answer it because I think I know what the answer is, but I don't remember looking that up or seeing that answer conclusively.
And I think
I
it came during the comment that child support is exempt because it belongs to the child. And I guess that's where alimony could be a little bit different. I know for a fact that alimony is not
Yeah,
listed, but I also am not
yeah. And I was like, I try to find everything I could, so maybe it's not, but I don't want to give an answer and then find out that I'm wrong about that. Sorry.
okay. So there were two other questions that were kind of, I would probably combine. One of them is what is meant by the term support, which is a pretty open question. And the other one is there any case law related to the specific calculation of the more than a half? For example, some state that one income must be more than double the income of one earner, and others state it can be more than one half of the total income of the household.
Okay. I don't know. I don't recall there being a specific definition of support, and I think that using kind of the cases that I described here, I think that leaves a window for us to be able to make an argument of what's considered support. Um, there is not a way there. I was not able to find anything, and I did look for how do we calculate that more than half the support. There is one case that talks about a a child support order that splits time sharing equally and based on equal contribution. And the court found that neither of those parents were able to, well, at least the one that was applying for the exemption was entitled to the exemption because they did not provide more than half. But I think you can use other factors too. If the other person is, getting, if there's, like I said, familial assistance, church assistance, anything else that can tip that 50%, I think, I think some of these are just not found. You're not going to find an answer, a black and white answer. This is where we can make those arguments and use that it should be construed in favor of our clients, the debtors.
All right. I have two more plugs. One of them is in the link for the materials. I'll include the copy for the slides, but I also dropped a few examples of claim of exemption forms that I found like randomly for different counties. Different courts will have them. So but depending on where you practice, Google those forms because the courts might already have one that is customized to the jurisdiction that you practice in. I also included a really helpful form from Jala that they have available on their website where it really kind of helps educate clients and walk them through the claim of exemption process. And the other plug, Adam, I was not ignoring your comment. I kind of waited until the end to do this plug. And Adam had a comment right after the waiver discussion. If anyone sees the Oculus cases, rent to own home improvement financing, they have them sign that waiver at the execution of the loan. And the Oculus waiver is also non-conforming, so interested if anybody is seeing this. So Adam put down his email. This is where I'm going to plug the Consumer Protection Union. And if you're a civil legal aid attorney, I'm going to drop the instructions on how to join. You can email me or Kevin Raven, and we'll add you to this listserv. If you're not familiar with the Consumer Protection Union is basically the consumer version of HUG, of the Housing Umbrella Group, where it's still small. We're starting to grow it again. We have monthly meetings. We have a great listserv, and these type of questions and these type of circumstances, that's a great research for the legal aid attorneys to communicate. There's also NACA. I'll include information about the National Association of Consumer Advocates in the email that I send out in case you're not familiar, because it's another great organization that you could join and ask these type of questions as well. So these meetings are going to be monthly. The ones for our CPU, Adam is usually there. And I think the listserv, Adam might have the most emails sent out to that listserv, and he always has great questions with great analysis. So feel please use the listserv if you're a civil legal aid attorney, because it really helps everybody in the community identify these type of issues and solutions to these problems. So that last one, Michelle, was really a plug. I have to say there were a lot of thank yous and a lot of kudos in the chat in case you haven't seen them. So I'll make sure to save the chat and send it to you so you can see a lot of the people appreciating a great presentation and a must-have for civil legal aid attorneys and public interest law attorneys. So it's the PowerPoint is not in the materials section yet because I was waiting for the presentation to be over. Once Michelle emails me the presentation, I'll make sure it's uploaded there. So if anybody has any other questions that we weren't unable to answer, or maybe even forms that you have, like claim of exemption forms that are particular to your jurisdiction that you would like to share, feel free to send those over to me and I'll upload them into the folder as well. So we went a little bit over time. I kind of expected this because this is a very popular topic. So, Michelle, I know how busy you are and how incredible you are. So, thank you for taking some time out of your schedule to put this great presentation for us. So,
Pleasure.
any last statements before we wrap up?
No, good luck to everyone.
All right. Have a great rest of your day and happy holidays, everybody. Bye bye.
Thanks.